Welcome to Unfair Housing. I'm your episode co-host, Alicia Magazu, and I'll be joined today by my colleague, Morgan Cardinal. Over the next several weeks, we'll discuss the history of housing segregation, which was caused largely through government policy, housing industry practices, and neighborhood behavior. Our discussions will focus mostly on the housing experience of Black Americans, but please understand Black Americans were not the only people who experienced housing segregation. The topics covered in this podcast will include historical accounts from the early 1900s to today. But to lay the foundation for future episodes, we'll begin with an overview of housing-related rights, or rather lack of housing rights, afforded to the Black population in the United States between 1600 and 1900. We'll review housing segregation from a national perspective, as well as narrow in on how Central Florida became segregated and has remained highly segregated today. As part of these discussions, we'll also highlight lesser-known civil rights pioneers whose heroism helped reshape policy, practices, and behavior over time. But first, let's talk about why these discussions matter. While some believe history belongs in the past, there is a distinct need to keep it fresh in our memory. We've all likely heard the saying, if you don't know where you've been, you don't know where you're going. So for us to desegregate neighborhoods today and promote integration, we all need a basic understanding of how we got here and what policies and practices continue to result in segregated housing. Many of the subjects we discuss, such as redlining and zoning restrictions, have had lasting impacts still present in today's housing market. This podcast is not meant to create division or instill guilt, but rather to educate our listeners on what shaped our neighborhoods and our social perspectives so we can better be guided in our efforts to improve our future and avoid repeating the mistakes of our past. We hope our conversations lead you to impactful dialogue with the people in your life and possibly even inspire you to get involved in improving your community. In the words of Nelson Mandela, education is the most powerful weapon which you can use to change the world. Keep in mind, discrimination is a heavy topic, so we ask that you please take care throughout this journey and pause episodes to take a breath when needed. Lastly, we welcome comments and lively discussion on the topics we raise, but we ask that kindness and consideration be used when making and responding to comments, and that you refrain from using threatening or violent language. Okay, let's get down to business. The 1600s marked the emergence of a prominent slave trade in the Americas, and along with it, slave codes. Slave codes varied by location and territorial rule, but they had a lot in common. Most slave codes considered slavery a permanent status. This means slave status was passed down to slaves' children at birth, so it was a never-ending cycle within a family. Slave codes also significantly stripped the enslaved Black population of their freedoms to participate in just about anything, and kept them from being able to make most of their own decisions. For example, slave codes in Louisiana allowed masters to have complete control over their slaves, and slaves had no rights to own property or make any decisions about their occupation. Similarly, in 1800s Florida, slave codes didn't allow slaves to own real or personal property, to sell anything of value, or offer their services for hire without permission from their owners. If a slave was found with property, Florida law allowed the property to be taken, and any proceeds from the sale were split between the assigned prosecutor and the treasury. None of the money went back to the slave. It was also against the law to teach a slave to read or write, nor were slaves allowed to have any reading material. So in short, slaves in America were generally not allowed to have or build wealth, despite playing a vital role in the success of the American economic system, and they faced physical and economic penalties if they even tried. One might assume these issues were only faced by those who were enslaved, but Black residents who were not enslaved also struggled with land ownership and economic equality. For example, let's take a look at Antonio Johnson, often referred to as Anthony. His story highlights how the accomplishments of one generation did not necessarily carry over to the next, which often kept Black families from passing on generational wealth to their children. Johnson was captured in Angola in 1620 and brought to Virginia. He was sold into the Atlantic slave trade and became an indentured servant. After completing his servitude, by law, he was able to acquire land, which he did. He gave 50 acres of that land to his son, who was also a free man. His son and his family lived and worked on the land until Anthony died. Following Anthony's death, an all-white jury decided the land should be seized from Anthony's son. The reason? Because his father was a Negro and therefore not a U.S. citizen eligible to own land. As a result, Anthony's son was stripped of his inheritance and the land was given to a wealthy white neighbor. Let me say that one more time. the land was taken from the Johnsons without any payment and given away to someone else unrelated to them simply because Anthony Johnson was Black. Now let's take a closer look at slavery in Florida. As a Spanish colony, the enslaved in Florida had legal rights and could purchase their freedom. However, once Florida became a territory of the United States in 1821, that changed. Black residents who were formerly free began to lose the legal rights they once enjoyed. For instance, Black Floridians who were free were now required to register with the government and pay a special tax for their freedom. And they could only participate in legal matters if a white person agreed to represent them. The result? Many fled the country to avoid the possibility of re-enslavement. Access to opportunity began to improve some during the Civil War and Reconstruction era. In 1862, President Abraham Lincoln signed the Emancipation Proclamation, declaring all persons held as slaves in the rebellious states were free. So keep in mind, the Emancipation Proclamation didn't free slaves in the Union. But this presidential proclamation set in motion the foundation for the formerly enslaved in the Confederate States to finally have rights. As the end of the Civil War neared in early 1865, Union General William Sherman and Secretary of War Edwin Stanton took on the task of how to address this change in status for Southern slaves. To reach that end, General Sherman had a discussion with Southern Black leaders in Savannah, Georgia, to discuss reparations for slavery. In that meeting, the leaders stated former slaves would need land now that they were free. 4 days later, General Sherman, in an unprecedented action, issued Special Field Order No. 15, which distributed to former slaves land that had been abandoned or taken from the Confederacy. The land included in the order ran from Charleston, South Carolina, all the way down to land bordering the St. Johns River in Florida. Another opportunity to extend basic rights to former slaves occurred in March 1865, when Congress created the Freedmen's Bureau, which was intended to provide newly freed slaves with aid such as housing, medical care, and employment. Additionally, the Bureau supervised former Confederate property, helped reunite families that were previously separated when sold to different slaveholders, and it helped recognize marriages between former slaves. So, for a brief period, it seemed as though the Black population was finally on the path to true freedom and equality. But, unfortunately, that was not quite the case. First, not all the efforts of the Freedmen's Bureau led to positive outcomes for the formerly enslaved. For example, the Bureau helped freed slaves obtain contracts for work, which sounds like a step in the right direction, right? Well, this effort didn't quite work out so well in practice. At the time, former slaves had very few opportunities for work, so many were essentially forced into contracts as sharecroppers or tenant farmers with landowners who were, of course, former slaveholders. The new relationship between the formerly enslaved and their enslavers didn't provide a wage. Farmers received only room and board and a small plot of rented land, and about half and sometimes even less of what they harvested. In the end, the relationship wasn't much different than slavery, and notably, it still did not provide an opportunity for Black workers to build wealth. Because these farmers were not paid a wage, they had to purchase goods and food on credit, often directly from the landowner for whom they worked. At the end of the year, the landowner would take its share of the profits from the harvest and reduce the farmer's share by the debt owed to the landowner. If the farmer's share of the harvest didn't cover the amount of debt, which it often didn't, the debt was carried into the next year, creating a perpetual cycle of indebtedness. By law, the debt tied the tenant farmers to the landowners. Any new contract involving a sharecropper who was indebted to a different landowner was voidable. Further, if a tenant farmer tried to escape their situation, the law allowed the return of the farmer to the landowner and afforded the landowner free labor. Sounds a bit like slavery, doesn't it? As if that wasn't enough, Southern states also passed laws restricting where, when, and to whom sharecroppers could sell their harvest. This often impacted the price farmers could charge for their crops and made it next to impossible to transport goods to where sales were allowed. All of this significantly impacted sharecroppers' ability to gain wealth, yet sharecropping remained a staple of the Southern economy for decades. Another significant event that reduced the effectiveness of the Freedmen's Bureau was the assassination of President Abraham Lincoln. Following Lincoln's death, Vice President Andrew Johnson, now President Johnson, overturned Special Field Order No. 15 and returned the land previously given to former slaves back to the very same Southerners who had rebelled against the Union. Additionally, President Johnson vetoed proposed legislation meant to expand the Freedmen's Bureau. Some of those vetoes were overridden by Congress, but ultimately the Bureau was abolished in 1872 and was largely inactive during the latter years of its existence. So Morgan, tell us what happened after President Lincoln was assassinated.
Thanks, Alicia. Hope for property rights rose again when Congress ratified the 13th Amendment in late 1865, which abolished slavery and involuntary servitude. But unfortunately, the passage of the 13th Amendment didn't completely abolish slavery. How? Because the 13th Amendment contains a significant exception that allows slavery and involuntary servitude to serve as a punishment for conviction of a crime. Now, at first glance, that probably sounds logical, but in practice, this exception allowed state and local governments to pass laws that criminalized minor infractions such as petty thefts and homelessness. And remember, while criminalizing poverty, the economic system in place prevented former slaves and black sharecroppers from gaining wealth and property. So once again, the law allowed for black slavery to remain because it gave former slaveholders access to free or low-cost black labor. Also, keep in mind, the language of the 13th Amendment has not been changed since it was ratified in 1865. Thus, this practice can be and still is used today. And even following the end of slavery, those who were free still did not have equal protection under the law like their white counterparts due to the passage of local laws. These local laws were often referred to as black codes and had similar effects as slave codes. For instance, in South Carolina, the law restricted the movement of black workers by requiring they get permission from their employers to leave the grounds of their place of employment, and required black workers to pay a tax if they did any work outside the agricultural industry. In Mississippi, a white person could arrest a black worker who left their employment if they decided the worker didn't have good cause. And of particular note, these codes often prohibited black Americans from owning or renting land, which of course further restricted their ability to create wealth. In short, black codes seriously limited black workers' ability to make their own choices. In response to the passage of black codes, Congress passed the Civil Rights Act of 1866 and the 14th Amendment. Both were passed without involvement from Confederate states and were passed despite President Johnson's veto. The Civil Rights Act of 1866 extended the right to inherit, purchase, lease, sell, hold, and convey land and personal property to all citizens of every race and color. The 1866 Act also protected all citizens from discrimination based on race. All that sounds great, right? Well, in practice, the 1866 Act wasn't quite as great as it sounded. It left a lot of room for interpretation, which at this particular point in history left the rights of Black Americans unprotected. It also didn't provide clarity on what type of action, government or private, was included in the limitations on discrimination. And it was largely ignored when the Supreme Court struck down a later civil rights law in 1875 that extended the 1866 Act to other areas such as public accommodations. The 14th Amendment granted citizenship to Black Americans and gave them equal protection under the law. This was, of course, met with opposition, which is why it took over 2 years to ratify. This is important because 38 states must approve or ratify an amendment before it is officially part of the U.S. Constitution. Because it took so long, some states that had originally ratified the amendment went through a change in leadership, and the newly elected officials did not support the state's ratification of the 14th Amendment, and in some cases withdrew their ratification altogether. Ohio is an example of one of those states. And disturbingly, Ohio did not re-ratify the 14th Amendment until 2003. Did you catch that? 2003. To aid the ratification of the 14th Amendment, Congress passed the Reconstruction Acts. The Reconstruction Acts did a couple of things. It put the South under military rule, and it gave Black men in the South the right to vote and hold office. These changes helped get the votes needed to finally ratify the 14th Amendment in mid-1868. Also in 1866, Congress passed the Southern Homestead Act, which was meant, at least in part, to provide land at a low cost to former slaves in the South. On its own, the Southern Homestead Act sounded like a decent deal, but it wasn't, both in practice and when compared to what was previously offered to white Americans. How? Well, prior to the Southern Homestead Act, Congress enacted the Homestead Act of 1862, which gave land to white Americans so long as they made efforts to develop it. The homesteader, as they were called, could get 160 acres of land for $10 to $12 plus a small registration fee. The only requirements were they had to either be a citizen or intend to become a citizen, be 21 years of age, and make improvements on the land with the intention of living on it. To put that into perspective, that would be like the government giving away 160 acres of land for around $235 to $365 today. Approximately 10% of the land in the U.S. was distributed through the Homestead Act. The Southern Homestead Act was the South's equivalent to the Homestead Act, which suggests Black Americans were finally getting an equal opportunity to acquire land. But the Southern Homestead Act only conveyed 80 acres of land, so half of what was included in the original Homestead Act. Further, the land was often forested, which meant it had to be cleared to make it suitable for farming. As we've already discussed, Black Americans had previously been largely prevented from engaging in the economy to build wealth, so having the means to clear a forest to farm was not a common occurrence. To add further insult to injury, much of the land was swampy and unsuitable for farming anyway. Lastly, and most significantly, white Southerners did not support the idea of former slaves owning and farming land. Much of the land that did actually make it into the hands of former slaves was taken through violence, intimidation, discriminatory practices, and so on. 1910 was the peak period for Black farm ownership, which saw 16 million acres in the hands of Black Americans. But by 1997, less than 100 years later, over 90% of that farmland had been lost. That's a staggering number, more than 90%. To put that into present-day perspective, the loss of wealth equals more than the gross domestic product of entire countries, such as present-day Finland or New Zealand. Examples of the brutality and racial housing discrimination experienced by Black farmers following the passage of the Southern Homestead Act include the stories of Reverend Isaac Simmons and Luke McElroy. In 1944, in Amite County, Mississippi, Reverend Simmons was lynched and his son was beaten by a group of white men who thought his land contained valuable oil deposits. Luke McElroy, a veteran of World War II, owned a farm in Cherokee County, Alabama, and was murdered by a white neighbor over a property dispute in 1949. There is no record of conviction in either of these cases. Think about the emotional and economic harm these racially motivated acts caused those families and hundreds of others like them.
And Morgan, as more federal laws were passed to give rights to Black Americans, opposition rose. Likely the most important example was the rise of the Jim Crow South, which many attribute to the Compromise of 1877 and the U.S. court decision in Plessy v. Ferguson. And in case any of you are curious, the term Jim Crow originated as a stage name for a blackface character in the 1830s and was later used to describe the laws that restricted freedoms of Black Americans. Jim Crow laws, much like Black codes, were designed to ensure Black Americans remained inferior, and they allowed significant elements of slavery to remain, despite federal law prohibiting it. They also played a major role in segregation. But you might be wondering how the Jim Crow South emerged if prior to the Compromise of 1877, so much federal attention had seemingly been paid to providing equal protection and opportunity to Black Americans. Well, let's start by reviewing the Compromise of 1877, which resolved a dispute over who would be president after the 1876 election. The two candidates were Republican Rutherford Hayes from Ohio and Democrat Samuel B. Tilden from New York. Neither candidate received the required number of electoral votes to win because 3 states' votes were still in dispute due to claims of intimidation and bribery of Black voters in South Carolina and conflicting results submitted by Louisiana and Florida. Hayes, who received more electoral votes than Tilden, negotiated with moderate Southern Democrats who agreed they would not challenge Hayes' claim to victory in exchange for the removal of federal military rule in the South. By removing federal troops from the South, there was no one left to enforce federal protections for the formerly enslaved, and the Democratic Party, which at this time was the pro-slavery party, gained control of much of the South. This led to the creation of state and local laws, also known as Jim Crow laws, that restricted the freedoms of Black Americans. The second punch to Reconstruction-era protections for the formerly enslaved was the U.S. Supreme Court's decision in Plessy v. Ferguson in 1896. Homer Plessy was an abolitionist who, with the help of others, organized an incident meant to test a new law passed in Louisiana that required separate train cars for white and Black travelers. Plessy, who was 1/8 Black, took a seat in a whites-only train car. When he was discovered, he refused to move and he was arrested. He took the matter to court, arguing the law violated the Equal Protection Clause of the 14th Amendment. Sounds like a pretty solid argument, right? A law that requires Black travelers to sit at the back of a train at all times doesn't give Black and white travelers the same traveling experience. Well, the court did not agree. In its ruling against Plessy, the court reasoned the 14th Amendment only protected political rights and was not meant to protect social rights. Using this rationale, the court stated the existence of 2 separate train cars for the races did not make Black travelers inferior, and was only perceived that way because Black travelers came up with that interpretation, an argument that's been made time and again throughout history. With this 7-1 decision, the Supreme Court created precedent that echoed across the country. Separate but equal was constitutional. Following the decision, laws separating people based on race popped up all over the country, in theaters, hotels, restaurants, shops, water fountains, beaches, and yes, in housing too. Separate but equal remained the law for more than 50 years until 1954 when the Supreme Court decided Brown v. Board of Education, which we'll discuss in more detail in a later episode. And as we'll uncover throughout the podcast, separate was very, very far from equal. So, as you can see, the federal government did attempt to provide some level of equity for Black Americans following the Civil War. But as you're also starting to see, federal laws were often weak and exploited, state and local governments passed other laws to undermine federal protections, and further, oversight and enforcement of federal protections were minimal. This reality will be repeated many times throughout our journey this season. I hope you enjoyed our discussion today, and I hope you have a better understanding of what laid the foundation for housing segregation and the stark wealth divide between Black and white Americans that still exists today. If so, give us a like, follow us, subscribe to the podcast, leave us a comment, share our information, all that.